Hello, I'm Nate Persily, and this is a course on the U.S. Law of Democracy. I thought I'd begin by saying sort of what's within scope and outside the scope of this course, because the law of democracy could mean many things. It could mean regulation of the entire political process, Congress, even constitutional law in general. But this is specifically a class about election law and voting rights. And so we will cover, several topics that are core to the question of the constitutional right to vote and regulation of the electoral process. And so this includes voting rights, ballot access, regulation of primary elections, redistricting, the counting of votes, as well as campaign finance. So I thought I'd begin by discussing what the Constitution says and doesn't say about the right to vote. One of the things that makes the US Constitution unique is that there is no guarantee of voting rights in it. This sets us apart from the rest of the world. Most constitutions around the world have a guarantee of a right to vote, but because at the time of the founding of the US Constitution and the US Republic, voting was quite limited, really, to white male property owners, there was no guarantee of a right to vote in the original document. There is in the Constitution, in Article 4, Section 4, something called the Republican Guarantee Clause, which says the United States shall guarantee to each state a Republican form of government. But that's never been seen as an enforceable provision by the Supreme Court, such that it would go in and sort of mess with the democratic processes within the states. Instead, what the Constitution does is it delegates to state legislatures the power for defining the franchise. For example, in Article 1, Section 2, the Constitution says that the House of Representatives shall be composed of members chosen every second year by the people of several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. So notice here that it doesn't give the right to vote for Congress, but instead says that the qualifications for voting will be the same as those that the state legislature determines for its own elections. And so we see that type of format in sort of other parts of the Constitution as well. Article 1, Section 3, as amended by the 17th Amendment, applies to the U.S. Senate and says that the Senate of the U.S. shall be composed of 2 senators from each state. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. And so that decision by a state to define the franchise for a state legislature then has knock-on effects for voting rights for Congress. And similarly, when it comes to the presidency, you see in Article 2, Section 1, that each state shall appoint in such manner as the legislature thereof may direct the number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. Notice again, it says that each state shall appoint in such manner as the legislature thereof may direct a number of electors. And so the whole process of determining who can vote for president is left in the hands of the state legislature. And it doesn't guarantee that any individual has a right to vote for president. In fact, the Supreme Court in Bush versus Gore made that clear and said specifically that the individual citizen has no federal constitutional right to vote for electors for the president of the United States unless and until the state legislature chooses a statewide election as the means to implement its power to appoint members of the Electoral College. And so I start with this because it is an extraordinary feature of the US Constitution that there is no sort of specific right to vote. And it also, as I said, makes this sort of course unique because so much of the innovation in this area has been done at the Supreme Court and then enforced by the lower courts, which have given sort of content to other provisions of the Constitution when it comes to voting rights. Just because there is no right to vote guaranteed in the Constitution doesn't mean that the Constitution doesn't speak to the issue. In fact, there are more constitutional amendments dealing with voting than any other topic. You can see that in the 15th Amendment, passed just after the Civil War, which says that the right of citizens of the U.S. to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. But notice that it doesn't say that you have a right to vote. It just says that the right to vote cannot be deprived based on race, color, or previous condition of servitude. And that's the same kind of format for the 19th Amendment, which prohibits discrimination with respect to the right to vote on grounds of sex, or the 24th Amendment, which prohibits the imposition of a poll tax, or the 26th Amendment, which prevents discrimination with respect to age with respect to voting rights. And so in each one of these amendments, there's a guarantee against discrimination, but not a substantive guarantee of the right to vote. So instead, what has happened is that the Supreme Court has read into the 14th Amendment a guarantee of a right to vote. And it's different than most other rights that we've seen sort of guaranteed in the Constitution, because the right to vote requires that the government do something, right? It requires that the government have elections and administer them and enforce them in particular ways. And so most of the jurisprudence regarding voting rights in the Constitution comes from the Equal Protection Clause, which says that no state shall deny to any person within its jurisdiction the equal protection of the laws. And so from that simple phrase, we get most of the jurisprudence coming out of the Constitution with respect to voting rights. And so that guarantee of equal protection passed after the Civil War, in the 14th Amendment, is sort of the critical phrase that then leads to the jurisprudence that we're going to be discussing in this course. Now, just as a roadmap for the lectures that are going to follow, I thought I would just sort of try to give you a framework in thinking about the right to vote. Because as I said, the right to vote is different than other kinds of rights like the right of speech, the right of religion, which are always about sort of preventing the government from infringing on a right that you have, sort of leaving an individual alone. Instead, when it comes to the right to vote, it requires we imply several different things at once. The first is the sort of more obvious dimension of the right to vote, and that's the right to participate in elections. And that includes the definition of the franchise. For, as I said, originally that included sort of only white male property owners who were able to vote, and then has been expanded because of the explicit amendments like the 15th and 19th Amendment, but also because of Supreme Court action, as well as action by Congress with legislation like the Voting Rights Act. But in this respect, we're talking about who is allowed to vote, who's allowed to participate, and who is not. And so that's the right to vote as the right to participation. But even beyond that, you've got a sort of second dimension of the right to vote, because it's not enough that an individual be able to go into a polling place and to cast a ballot. It depends what he or she sees when they get there, right? And so in addition to that right of participation, there's this right of expressive association, the ability to find a candidate that you would like to vote for, or a political party to affiliate with, and to express that preference on the ballot. And so it's critical that you both sort of be allowed legally to vote, but also that the regulation of the political process not prevent you from, affiliating with parties and finding a candidate that you would support. There are plenty of dictatorships around the world that have had elections, but if you only allow one candidate on a ballot, it's not much of a democracy. So participation, expressive association, and the third notion is this right to vote as an aggregative right. And by that, we mean that it's not enough that you be able to cast a ballot and that you actually see a candidate that you want to support when you get there. It also depends how those votes are aggregated and counted. And so we spend a lot of time in this course in discussing redistricting and gerrymandering, because so much of the sort of weight of someone's vote can be determined by how those votes are grouped together. And so this is, again, another dimension of the right to vote that makes it different than the right of speech, right of religion, and other rights in the Constitution. And finally, it's not enough that you be able to participate or that you be able to find a candidate that you want to support and that the votes be counted correctly. Sort of implicit in the whole idea of the law of democracy is that your vote would make a difference. And so we have to think about the right to vote and how it's tied to governance. And so we discussed the campaign finance cases, which really ask the question whether elections are determining the policies that get passed in Congress and state legislatures and other representative bodies, or whether campaign donors are the ones really calling the tune. Because if the campaign finance system is arranged in such a way that it's really impossible for voters to have an impact on policy, then that also undermines the law of democracy.